I may be missing a few.
And do you recover some items yourself during the execution of that search warrant?
I do.
What do you recover?
I recovered from the trash can outside next to the home a shirt, a dark-colored Dickies shirt that had some paint on it, white paint.
Can you describe the white paint that you saw on that shirt?
It was like someone had wiped their hand on their shirt.
And you're indicating towards the front of your body. Is it the front of the shirt?
Yes.
At some point in time, was there a photograph taken of that shirt?
Yes.
Do you recover anything else from that location?
I did not.
Did you witness the recovery of other items from that location?
I did.
What else did you witness being recovered from that address?
Officer Bolden confiscated some proof of residence in the back room. It had a bed in it. Looked to be a bedroom. There was other debris and clothing, men's clothing, in that room.
When you say proof of residence, what are you talking about?
It would have been documents, papers, indicating belonging to Mr. Stuart Horatio Lewis.
And at some point in time during your investigation of this incident, did you become familiar with the person of Stuart Lewis?
Yes.
If you were to see that person, would you recognize him?
Yes.
Do you see that person in court today?
Yes, he's seated at defense table wearing the yellow shirt.
Indicating for the record identification of the defendant in this matter. And did you see that paperwork that was confiscated by Officer Bolden that had information regarding the defendant or the defendant's name on it?
Yes.
Was that also photographed at some point in time?
Yes, it was.
What else did you see that was confiscated from the location?
I observed a plastic baggie containing numerous Ziplocs of marijuana that was on a couch in the front room, and Officer Penn confiscated that.
And the Ziplocs that you saw in that other baggie, how many were there total?
There were numerous, I believe 17.
Would looking at anything refresh your memory of the exact number?
Yes.
What would that be?
That would be the investigator's report or the lab report.
The request for laboratory service through the Detroit Police Department?
Yes.
May I approach the witness, Judge? Hand you a one-page document. Can you tell me what that is?
This is the lab report for the marijuana that was confiscated.
And does that refresh your memory as to the number of baggies that were there?
Yes, it was 18 Ziplocs of marijuana.
And was that placed on an evidence tag or lock seal folder at some point in time?
It was placed on that would have been a lock seal folder number.
What was that lock seal folder number?
That would be N057-271-94.
And in your experience as a police officer, this confiscation, was it consistent with anything?
It was consistent with possession with intent to deliver.
Why is that?
Based on the manner of packaging and the number of smaller Ziplocs that were inside of that plastic baggie.
Were each of those 18 Ziplocs approximately the same size as each other?
Yes, they were.
Did you see in the location or in the possession of any of the officers recovering anything with which to consume that marijuana, such as rolling papers, pipes, things like that?
I did not.
And have you made arrests or confiscations of drugs such as marijuana before in your experience as a police officer?
I have.
And have you been assigned to the narcotics section at some point in time as well?
I was.
And is that information based upon all that experience that you've had with regard to these incidents?
Yes, it is.
And Your Honor, I would have to mark this as People's Proposed Exhibit 9 and admit it.
9? I have 6 exhibits marked.
We did the
pictures.
The 2 videos.
Oh.
7 and 8.
Okay.
Yeah.
All right. May I put my signature on the disc, by the disc, or
I
the
didn't.
paper?
I just did them via the computer. I didn't put them on like a disc.
Okay. So they won't have a sticker on it?
Right.
Okay.
7, 8 are videos, and then 9 is document.
Oh. Here, why don't you put it on first? Thank you.
I would renew my motion to admit people's proposed exhibit 9, the laboratory notebook. And that is the preliminary lab analysis. Object without argument. All right. May I publish to the court? Yes. Did you observe any other objects confiscated from that location?
There was also some paint cans,
What
at least
type of
one,
paint can?
at least one spray paint can that was confiscated from underneath the kitchen counter.
And who made that confiscation?
Officer Bolden?
And you saw that as well?
Yes.
Other than taking part in the execution of the search warrant, did you do some other activities with regard to investigating this matter?
Yes, I reviewed a video.
And did you investigate into the individuals that were living at that home at that time on Exeter, the 19942 Exeter, and the vehicles that were going to that location?
Yes, I did.
And other than the defendant, were you able to identify anyone else as coming and going from that location?
One other person that I was aware of.
And was that person male or female?
Female.
Do you know that person's name?
Jennifer Graves.
And you know her relationship to the defendant?
It's my understanding that they're boyfriend-girlfriend.
Did you investigate or see anything with regard to any vehicles coming to and from that location?
Yes, a white Buick belonging to Ms. Graves. It was actually at the location upon the search warrant execution, as well as Ms. Graves.
And with regard to your investigation, did you investigate the location of this address at 19942 Exeter with respect to the location of the wall at 200 West Fair?
Yes, I did.
What's the distance between these two locations?
It's directly across the street. If you stand on the front porch of the Exeter address and look directly across the street, the wall that was painted on is directly across the street.
What color was that wall at the time?
Brown.
And did you take part in investigating into incident that happened back in 2013 with that wall?
Yes.
Was that wall still brown at that time?
Yes, it was.
And have you taken part in investigating tagging cases in your experience with a Detroit police officer?
I have.
And are you assigned to a unit that looks into these incidences themselves?
Yes.
Have you received any training regarding these types of cases where tagging or spray paint is involved?
Yes, it would be through experience and conversations with other graffiti vandals, as well as other police officers.
And in your experience and training, do individuals make letters in ways differently than they would on a piece of paper as they would on a wall?
It can happen that way.
Speculation. Just the same. How many investigations have you made into graffiti or tagging or things like that?
Over 100.
And have you testified in the cases before regarding tagging and graffiti and things of this nature?
I have.
And have you received training in identifying tags and things of that nature?
Yes.
When looking into this case and looking into the incidents regarding this, did you have an opportunity to look at the graffiti that was on the wall in 2013 with respect to this matter?
Yes.
Did you see anything consistent with that and with what you saw with regard to the graffiti that was there on October 19th, October 19th, October 20th, 2016.
Yes, not only were both instances directed at a certain individual, although they were different individuals, the handwriting in both instances appeared to be the same.
You said you also reviewed a video as well?
Yes.
And where was that video from?
That was from 200 West State Fair, and it was of the side of 200 West State Fair, which would include that wall, and part of the roadway and the front of the homes on the opposite side of the street.
Would the opposite side of the street be the Exeter addresses?
Yes.
In reviewing that video, did anything spark your concern or take note of those things, something happening?
Yes. I had been made aware of the fact that Mr. Lewis had been released from the DDC on the 19th, somewhere around 8:15 p.m. When watching the video, you observe at approximately 8:34 p.m. a white vehicle that fits the description of Miss Gray's vehicle that was parked at the house on the day of the execution of the search warrant. You see this vehicle drive past the camera and pull into the driveway or the front lot of the Exeter home. Within 4 minutes of that vehicle pulling into the front of that home, you can see a figure walking across, and actually crosses across the taillights have a glare, so you can see that the person is actually walking from the front of the Exeter home directly across the street toward that wall.
And is this video continuously running video, or how does this video work?
This video is motion censored, and so it takes a large object or a close object to set it off, and it only runs for a short period of time.
Did you watch this video over the course of some time to indicate that this is what's happening on this video continuously?
Yes, I watched the entire video that was supplied.
And is a person's movement, one person's movement, not walking directly towards the camera enough to keep the camera going?
It is not.
And if you were to look at a still image of those portions that you described, would you recognize them?
Yes.
Directing your attention to the screen next to you, can you tell me what that is a still image of on the screen?
Can I stand? I can't see with the glare. Yes, that is the image of the camera shot at 200 West State Fair.
And where would the defendant's home at 19942 Exeter be with respect to this screen?
So you see a garage directly to your right, then you're going to see some brush or weeds, then you're going to see the formation of a house, and then next to that house is going to be the Exeter home.
And where is the 200 West State Fair location, and particularly the wall at issue?
So the 200 West State Fair building is this brick wall here, and it runs down all the way down just past the Exeter home in question. The wall would be just right around where that light pole is.
And Your Honor, at this time, people would move to admit People's Proposed Exhibit 10 to video. No objection for the camera. Maybe for exam purposes only. And this is the clip starting at 8:34 p.m.
Yes.
And then the video cuts out at approximately 8:35?
Yes.
And that was that vehicle that you described consistent with the defendant's girlfriend's vehicle?
Yes, it is.
I have showing on the screen another video clip, People's Proposed Exhibit 11, with a military time of 20:38 or a time of 8:38. Is that the same street and the same location that you described previously?
Yes.
At this time, people would move to admit People's Proposed Exhibit 11 for objections for ban purposes.
So admitted.
It is that light at the left side towards the end portion of the street that we can see. Is that a vehicle?
That's a vehicle approaching. That is what set the camera off.
What?
Did you say sub camera?
Set the camera off.
Oh,
Set the
okay.
camera off.
Can you indicate for the court what you saw there near the arrow?
I saw a figure pass in front of the vehicle that's parked at the Exeter home. You can see it. It blocks out the glare of the rear tail light. It walks from that home directly across the street, and just before the camera cuts out, you can see what appears to be an object, possibly a paint can that's being about to be shook.
In the hand of that person?
Correct.
I'm sorry, you'll have to back that up.
I'm going to play it again.
Okay.
It is the arrow on the back of the car?
Yes.
Or on the back portion of the car, not the tail light itself?
Correct. Right there you see the person cross. He's crossing the street.
And is that the area where the arrow is now?
Yes.
And
You can actually see it really well from where I'm standing.
here we go. As to People's Proposed Exhibit 12, is that a screen grab of the
I'm sorry,
portion?
12?
Yes. This is the last one, 11?
Yeah, okay.
Yes, it was.
Okay.
The last video.
Okay, give me a minute to write it down. I've never done it like this before. Okay. As to People's Proposed Exhibit 12, go ahead.
Is this a screen grab of the video itself?
Yes.
And the little box being the portion of the video that's enlarged here?
Yes.
20, 38, and 57 seconds?
Yes.
And do you see the same figure you saw in that underneath the, or above the arrow?
Yes.
What do you see there?
I see the object. I see the person. You can see his head. You see his body. You see his arm. And it appears that there's something in his hand.
Is that consistent with what later is located on that wall?
Yes, that's the area.
At any point in time in the, how many hours of video did you watch with regard to this video?
There were several hours. Went into the next day. In the next day, in the afternoon hours, you see people stopping. You see people get out of their vehicles and take photographs. Some people even drove by, turned around, and drove back by very slowly.
At any point in time prior to 8:38 or after, do you ever see anyone physically approach the wall themselves other than this figure approaching at 8:38?
No.
May I approach the witness, Judge? I'm handing you what is People's Proposed Exhibits 4, 5, and 6. Can you tell me what this exhibit is?
4 is the top portion of that is a photograph of one of the documents that was taken. from the bedroom at the Exeter location by Officer Bolden. It shows a signature of Stuart Lewis dated 10/10/13. He's also printed his name on this form. The photograph below is a photograph of the Dickies shirt that I confiscated from the trash can beside the Exeter home. Exhibit 5 is a photograph of the Dickies shirt in its entirety on the front side of it, where you can see the paint on the front of it. The photo below that is another photo of the same document, just in a different area that was confiscated.
Different portion of the same document?
Yeah, a different portion of the same document. That was confiscated from that bedroom. It has some handwriting on it. Did you want me to read it? Or?
Is that handwriting consistent with any other writing that you saw with regard to the investigation of this case?
Yes, it's consistent with both the incident back in 2013 and the most recent incident.
When you say most recent incident, are you talking about the writing on the wall indicating kill all police, kill James Craig?
Yes.
What's the next exhibit?
The next exhibit is Exhibit 6, and this is another form that was taken from that back bedroom on the top portion of that exhibit. This form is dated 11/1/13, is signed by Stuart Lewis, and the handwriting on this document is also consistent with that of the handwriting on the wall for both incidents.
And with respect to the document that has 3 portions to it, what's the date associated with that document?
The document at the bottom portion of Exhibit 6?
No, the document that has, it's depicted on all 3 exhibits. A portion of it is depicted on all 3 exhibits?
Yes, okay.
What's the date on that document?
That date is 10/10/2013.
And is that the document that has some writings about Asia White?
Yes, it does.
I would move for the admission of People's Proposed Exhibits 4, 5, and 6, and ask to publish them.
Them purposes only, Your Honor.
All right.
And it appears them purposes only.
In investigating this case, did you ever have any contact with the girlfriend of Jennifer Graves of the defendant?
Yes.
Did you ever notice anything about her gait or her ability to walk?
She's a much larger woman. She complained of having back problems when we were at the house. Her figure is definitely not consistent with the figure that was seen in that video.
Do you see anyone in court today consistent with the figure that you see in that video?
I do.
Who is that?
Mr. Stuart Horatio Lewis.
Oh, this happened in the city of Detroit, County of Wayne?
It did.
Nothing further this week.
Afternoon, Sergeant McCain.
Good afternoon, ma'am.
You don't purport to be a handwriting expert, do you?
No.
Okay, and then would you agree with me, hate to do it, but Deputy Goldsmith's figure is consistent with the individual in that video as well, correct? A tall, not so heavy man?
Sure.
Okay. Now, I want to get some information from you. You said you watched several hours of video, correct?
Yes.
In fact, were you involved in the testing of the cameras with Officer Hessmark?
I was in telephone communication with him, but I was not there. I was not present.
Okay, but you are aware that there was a significant amount of time spent looking at video from 5 until 11:30 on the 20th, correct?
Yes.
And are you aware, did you see his test?
I didn't. I saw the video of, if you're referring to the test, when he actually walks out to the area where the wall is, where you can see the area that you need to watch.
Correct.
Correct.
Yes.
And then you saw that it was not continuous, but he was captured by those cameras, correct?
That's correct.
All right, and so your testimony here is that what we've seen, these two snippets, if you will, one of the vehicle driving down the street, and that the next one with the vehicle, and I don't know whether that's east or west, help me. The white vehicle that's traveling toward the Exeter address, is that east, west, north, or south?
This is embarrassing. I believe that's north.
State Fair travels north and south.
Okay, State Fair is north and south, so then, let me turn around, I gotta see a map. Yeah, State Fair is east and west. So Exeter is north and south.
Wait, one at a time. Okay.
I said off the record, so we wouldn't have to write them.
Oh, well, she had started testifying though, but, okay.
Okay, State Fair is east-west street, yeah.
Yes.
So coming down Exeter is gonna be
That would have been northbound. Exeter.
northbound toward the house,
Correct, from State Fair.
southbound, second clip.
Correct.
And you didn't get a license plate off that vehicle traveling northbound, correct?
No.
But when Officer Pestmark is doing his test, he's up upon the building, correct?
He is.
And the cameras are picking up disjointed clips of him, correct?
Yes, I believe so, yes.
And he's not moving up and down the building in a vehicle either, is he?
No, but there were vehicles traveling up and down the street. If memory serves correctly, that would have been setting the camera off.
Okay, and so then just
Yeah.
his body would not set off the camera?
Correct. However, in daylight hours, it may be slightly different. I can't say for sure, but if my memory serves me correctly, there were vehicles and other traffic that was setting that camera off near the camera that kept the camera coming on and off.
Now, I want to go back to the video, so I'm going to ask Ms. Sandmark to be kind enough to get them ready, but I'll stay away from there initially so we can move through. You indicated that upon review of the vehicle, you saw a white Buick belonging to Jennifer Graves, correct?
You're talking about on the night of the search warrant execution?
Is there a video of the search warrant execution?
I'm not, there should be, I don't know, I'm not sure. I just know that you're talking about, because the vehicle was parked at the house the day we executed the search warrant.
Correct, but as you look at the video, you are not telling us that that white vehicle is Jennifer Graves' car, is it?
I'm saying it's consistent with Jennifer Graves' car. She drives a white Buick Regal with it appears to be a
I just wanted to make sure
sunroof.
you said consistent with.
Yes.
Okay, thank you. And the figure that you see, I want to go to the second clip, please. Yes. Okay. Does the image that you see emerge south or north of those tail lights down there? And we've said that.
Okay, so he would have been south of the vehicle. You can see the figure pass across where the glare is on the back of the taillights of that vehicle. You can see the glare go away and then reappear, and the figure continues to cross. And actually,
You're going in this direction, and the video we're talking about goes in that direction. So which glare are you speaking of?
are you speaking of the vehicle or the person crossing?
I don't think, is the person the glare you speak of?
Yes, okay,
Oh, I'm
so
sorry.
there's a glare that's a vehicle that's traveling southbound.
Correct,
That vehicle passes.
correct.
Then if you concentrate your eyes on the vehicle that's parked at the Exeter address,
Correct.
You see a figure pass across the taillights of that vehicle parked in that front of that Exeter house.
Yes.
You see that figure cross the street. And actually from this angle, it actually appears that person's wearing shorts, baggy shorts. He walks across the street, and it almost appears that he turns and looks back as well at the house, and then turns back around and appears to have something in his hand at the very end before it
And what does
blanks
that
out.
appear to be in the hand?
It's an object. I can't tell what it
Could
is.
it be the hand itself?
It appears that something's in that hand.
I
but
got you. But it could be a hand itself,
Possibly.
correct? Because you don't know if this individual has the spray cans in the baggy shorts.
I have no
correct? You
idea.
just see hands.
That's correct.
Or something raised up, okay. And so then I want to talk about the things that were recovered from the house. You said you personally recovered the dark shirt with the white paint on it.
Yes.
Any way to tell how old that paint had been on that shirt?
No, I have no idea.
Okay, but you didn't recover any paint cans out of that garbage can, did you?
No.
And then the one paint can that is recovered from the house is silver spray, silver paint,
Yes,
correct?
I believe
Auto
so.
paint, correct?
Yes.
And the Kill James Craig is painted in white, is it not?
It's painted in a light color. I didn't actually observe the wall, but I believe it's white paint.
Okay, and then the Kill All Police is painted in black.
That's correct.
So you did not recover neither a white or black spray paint can from Mr. Stewart's house, correct?
No, we did not.
I got it wrong. Kill All Police, would you agree with me, is in white?
Yes.
And Kill James Craig is in black?
Yes.
Thank you, Ms. Smith. Where is the camera on the State Fair building?
It would be on the south, let's see, southeast corner of that building, facing north, down Exeter.
So, I've even gotten confused myself. Closer to the graffiti or farther away?
Farther away.
You observed some of the documents Ms. Van Mark was showing you with Mr. Lewis's signature on it?
Yes.
Is that the handwriting that you see on the wall?
Yes.
The signature?
No, not the
Because
signature.
the writing on the wall is not in cursive, is it?
No.
Okay.
No,
but
I
his-
misunderstood your question.
His
ma'am.
signature is in cursive, right?
That's correct.
You're the affiant on the search warrant itself, correct?
Yes.
And your warrant allowed you to search phones, correct?
Yes.
Did you find any communications related to Kill Police or Kill James Craig on those phones?
I did not review the phones, ma'am. Those were dumped by cyber crimes and then reviewed by the officer in charge.
You don't know of any evidence of any
I'm unaware of it.
like that?
I'm unaware of it.
And then, did you recover any weapons of any type from Mr. Lewis's home?
No.
No communications from him that you know of regarding this graffiti, correct?
Just the graffiti itself, ma'am.
But in applying for your search warrant, Ms. Whitehorn had told you that Mr. Lewis had 4 guns, correct?
I'm sorry.
Did you not indicate in your search warrant that you had gotten information that Mr. Lewis had at least 4 guns?
That was the information that Ms. Whitehorn had given me upon last she knew.
Okay. Did she tell you she hadn't seen him since, or interacted with him since 2012 or 2013?
She told me that there had been some time that had elapsed since their communication. I did take a statement from her on the day that I met with her,
Okay, but you found the mention of the 4 guns to be valuable to you in requesting the warrant?
Absolutely.
Okay, thank you very much. I have no further questions. You didn't recover shorts, did you?
No.
No other items of clothing with paint on it?
No.
Were you there when you were there for the execution, not the execution, but you did the search. Did he have paint on him?
He didn't have paint on him, but I think he was wearing shorts at the time.
Okay. Thank you very much.
Sergeant McKay, as part of your investigation into this incident, did you ever check the distance in time or distance-wise in miles between Exeter, the Exeter address at 19942 Exeter and the Detroit Detention Center?
Yes.
And what's the distance or approximate time it took you to reach that distance?
It was 4 or 5 miles, and it took us about 10 minutes to get there in heavy traffic with school letting out.
Okay, so at a different hour than 8:17 or 8:15 p.m.?
Yes, ma'am.
A more highly trafficked time?
Absolutely.
With respect to questions about shorts, did you, as part of your investigation into this, review any of the other video with respect to this case?
Yes.
Did you see the defendant wearing shorts in any of the video as part of this case? If you can recall.
I would have to review the video again, ma'am, to answer that.
You're aware that he was arrested and taken to the Detroit Detention Center previous to the 20th and then released on the 19th?
Yes.
And in processing someone, are they taken to the Detroit Detention Center in the same clothes that they're wearing at the time, barring other circumstances?
Yes, they are. Thanks, sir.
With respect to your investigation and search warrant execution, do you take the clothes that someone's wearing at the time from them, typically?
No.
And you said you believe that the defendant was wearing shorts at the time?
At the time of his arrest, at the search warrant execution, yes.
And at some point in time after the search warrant occurs, is the defendant arrested again?
Yes.
Is he arrested on the scene or some later time?
He was arrested at a later time.
And did you take part in any arraignment of him at some later time?
Yes.
Did you notice anything about his clothing at that time?
He was wearing a coat that had paint on it.
And do you recall where the paint was on his coat?
On the front of the coat.
And when you say on the front, you're showing to the chest area of the coat?
Yes.
Going to show you a little bit of People's Exhibit 7, the video involving the incident at the defendant's home on the 17th. Do you recognize, pausing here at 4:07 and 11 seconds, do you recognize any vehicles that you saw or that are consistent with what you've seen at the Exeter address in this video?
Yes, the white Buick with the sunroof.
What is that consistent with?
That's consistent with Jennifer Graves' vehicle.
Jennifer Graves being the girlfriend, or the defendant's girlfriend?
Yes.
And going forward, pause it here at 14:07 and 21 seconds. Do you see anyone depicted in the right lower quadrant of that?
Let's put it 1607, 1607 and 21.
Yes, 4:07 p.m.
Oh, okay.
Do you see anyone in the right quadrant on the left, or excuse me, left lower quadrant?
Yes,
And who is that?
that's Mr. Stuart Horatio Lewis.
And does he appear to be wearing shorts in that?
Yes,
Are those consistent with what appears to be baggy shorts of the person walking across the street in the video at 8:38 p.m. on the 19th?
yes.
I don't have any further questions.
Just briefly, Sergeant McKay, you don't know that that's what he had on when the police arrived here
Which time?
on that day?
On the date that's in the
In
video?
the video, yes, yes.
Well, he's wearing them in the video, so that must be what he's wearing.
Well, no, why must it be? That is during the incident with the tow truck driver, correct?
Yes, that's what you're
Tow
asking.
truck driver leaves, he's
Yeah.
still at home. You don't know that later, when the police arrive, that he's still wearing those articles of clothing, do you?
Oh, I don't know what he was wearing when the police arrived, whenever they did. You'd have to ask them.
Okay, thank you. No further questions.
I don't have any further questions.
Thank you, Sergeant McKay. You may sit down.
Just leave it on the chair, please.
Okay.
Your Honor, at this time, the people are not going to have to call Officer Bolden. I'm not calling any other witnesses with respect to this. If counsel has no witnesses, and I don't think she does, I would make a motion to find the defendant over on the charges contained in both complaints and warrants. I did put counsel on notice, well, previous counsel, I don't know if Ms. Peterson and I have spoken about this, that count 3 should actually be a 1-year misdemeanor as to...
I'm sorry, which felon are you referring to?
I'm sorry, the false report or threat of terrorism, delivery, manufacture of marijuana.
All right, so right now, count 3 is malicious destruction.
Of a building less than 200.
Yeah.
The evidence that we have suggests it's a higher amount, but it's still a misdemeanor, so the defendant would just be a notice at this time because he did not get an exam as to that. But that would be the 750380 subsection 4, the 1-year misdemeanor, the amount being $761.30, that being between 200 and 1,000.
Let me get that number again, 750-3.380 subsection 4.
That's correct.
And
And
that's
that's
the 1 year.
200 to 1,000.
Mhm.
And then
that's the 1-year misdemeanor?
that's correct. And then our intention to amend the habitual offender notices to third offense based upon the information we've received, and we will have to do amended information to that as well. But we would move to habitual third, which is right now habitual second, habitual third. And then we'd be moving to bind the defendant over on the charges contained in the complaint and warrant on that matter, and as to the charges contained in the complaint and warrant on the felonious assault, felony firearm, that also would be amended to third offense notice based on the information, and we would have to do an amendment.
I'm sorry, so what are the other 2 offenses, because he was charged second offense?
Correct. He had the Wayne County case, the attempt, excuse me, the attempt possession with intent to deliver in 2002, and then we located that other offense, and I will have to provide an amended information for that.
What
But that's
other-
just a notice provision.
I'm sorry, what other offense?
This would be the receiving, concealing stolen property over 100 and larceny from a motor vehicle offenses out of the Muskegon court.
And when was that?
That being on case number 8627714 FH.
So he has a prior from 1986 and one from 2002?
Correct. And so those would be to habitualize. That's just notice provisions at this point. Okay? So the people would make a motion to bind the defendant over on the amended count 3 as to the false report of terrorism, delivery, manufacture of marijuana, and malicious destruction of a building, 200 to 1,000, 1-year misdemeanor, and move to bind over on the felonious assault, felony firearm as well.
May I intervene with you, sir? Okay, Your Honor, as to the felonious assault, felony firearm, in the first case, I believe there is a question of fact. Similarly, as to the possession with intent to deliver marijuana in the second case. What I take exception with is the false report or threat of terrorism, and I will try not to be too long, but I would ask the court to consider this. Where our Michigan courts have only spoken regarding the threat of terrorism is in the Quigley and Ostentowski cases. Both of those are cases that involve not only a threat, but some action in furtherance of that threat. Now, I know the prosecutor is probably going to refer to 75543M.2, which says it is not a defense to the prosecution that the defendant didn't have the intent or capability of committing the act of terrorism. But if the court looks at the intent of the legislature when they put in place the Anti-Terrorist Act of Michigan, it was in response to 9/11, an actual terrorist act. This is nothing more than graffiti and angry words, Your Honor. And what I ask the court to do is look at these factors first. One, there is no evidence that the felonious assault incident angered Mr. Lewis in any great way. The officer testified that he was arrested without incident. He cooperated. He told him where the BB gun was. There is no report of any incident happening at the BDC. I submit to you that there is nothing to spark his hatred of police or the hatred of James Craig. If that be the case, everybody arrested in the city of Detroit would be a suspect in this case. But what we do see is on the video, there is no depiction of the individual or anyone committing the act. There is no, what we see is walking. And we cannot be certain that it is Mr. Lewis. In fact, what Sergeant McKay indicates is that it's someone consistent with him as well as one of your deputies. But I would submit to this court that the video at this point is just simply not reliable. There is no evidence of the paint that we see on the wall, no black, no white in Mr. Lewis's home that would be consistent with the painting of Kill All Police and Kill James Craig. But their search warrant suggests that there would be weapons. They found none. Communications with others. They found none. In fact, there are no acts in furtherance of this threat. And now I will lean strongly on the statute, which says first, the threat, making a terrorist threat, requires that one, the person threatens to commit an act of terrorism. And then when we refer back to section 75543, the act of terrorism requires all of these things. One, that the act be a violent felony. Two, that the person knows or has reason to know that that act is dangerous to human life. Thirdly, that that act is intended to intimidate or coerce a civilian population, much like in the Ostentowski and Quigley cases when they're alleging that they're going to do something, I'm going to blow the building up, I'm going to blow the school up, and they don't have the means, and it amounts to a false threat. However, the second prong of that is that it be intended to affect the conduct of government or a unit of government through intimidation and coercion. And what we heard from James Craig is that they didn't do anything different. he took it seriously. He wasn't even as concerned about himself as he was his other officers. So I submit to this court that this is not rise to the level, even in a probable cause standard, of an act of terrorism. An act of terrorism, Your Honor. This is ugly words. It may be anger, disgruntlement, but certainly it is not the threat of a terrorist act as we have come to know them and to know exactly what terrorism is. What it does is just turn any angry words into terrorism. And I submit it is not. If that be the case, lock her up would be a terrorist threat. Build the wall could be a terrorist threat. Kill James Craig, kill the police without any acts in furtherance does not impute to Mr. Stuart, if in fact he did write it, an intent to affect the conduct of government through intimidation and coercion. We know that it did not, in fact, affect the conduct of government. And I would submit to this court that the count of false report or threat of terrorism should be dismissed in as much as the evidence is insufficient on this record. So thank you.
And Your Honor, what we have here is not just speech by the defendant. It's not just showing distaste or expression or saying what he feels about police. We're talking about him making commands, giving orders, making threats. And what the important thing to look at in this manner, and in almost every criminal case, is the intent of the defendant, not its result on the officer, or its result on the complainant, or its result on the person. It is the intent of this individual. And what this defendant intends to do is to threaten people, to terrorize people, to command people, to order them around, and to make them scared of him, make them concerned of him. And we see that in his plan, his common scheme with regard to Asia Whitmore, with regard to James Craig, with regard to the police. And whether or not all the police or James Craig are terrified or he's actually effective in his manner in which he's going about these things is not determinative of whether or not his intent is to do so. We know that the vast majority of the time, the police, the chief through James Craig or any police officer is trained, is taught, is in a situation where they don't run from danger, they run to it. And that's the point of police and the reason we have them. In going to about these statutes being written after 9/11 and all of that, we know police ran into those buildings as these things were going on. It doesn't matter that the police say, that's a threat, I take it seriously, but I still act as a police officer in response to it. They're not going to stop going on Exeter. They're not going to stop driving down State Fair and policing in those areas. They do take it seriously enough to know that they're investigating it, that they're looking into what's going on, and that Chief Craig was concerned for himself, but mostly for his police officers and any police officers acting in this area with respect to those threats that were put on that wall. Now, I would submit to the court that this is not just a speech thing. This is not just saying that he dislikes the police, or even saying it in, why isn't it? Because these words are commands. Kill all police, kill James Craig. These are acts that would be violent felonies under the laws of the state.
Who is he telling to do this?
Himself, others, he's putting it publicly on the wall.
That this is how he feels. He wants the chief dead, he wants all the police dead.
I don't think that it's just how he feels, Judge. He's putting a command on the wall. Kill all police, kill James Craig. He's not saying, I hate the police, or F the police, or things like that. He's making a command, kill all police, kill James Craig. These are commands, these are threats, these are orders. This isn't
I really disagree.
For the police.
I disagree that this is a threat. I agree that it's a command to everybody that passes that wall to read, kill all the police, kill James Craig. Now I'm trying to figure out, why is this a terrorist threat with no other act in furtherance other than spray painting on the wall, kill all the police, kill James Craig, which is,
And we don't need,
disconcerting in and of itself to see your name plastered on the wall, either saying you got AIDS or treating someone or anyone or everyone to kill the police. Why is that not protected speech?
and I would submit to the court that it's not. This is not protected speech. You can't go around and say a fire in a crowded elevator or in a building or in a movie theater. That's something that is caused for the civilian population to be terrified, to coerce them into running from that location, hurting someone in trying to flee or things like that. Try to affect the conduct of government or a unit of government through intimidation or coercion. These things aren't speech. Just because they're words doesn't make them protected speech.
I'm not following your argument. I'm really not. I'm trying to, but I'm not following your argument. This is clearly speech. I guess the question is, why isn't it protected? Why isn't this protected under the First Amendment? I look real carefully at the statute as well, and I had to do quite a bit of reading and scratching his head and writing the things to try and figure out how does this fit under this statute.
And I would read you this. Only true threats are prohibited under the statute. In People v. Ozentowski, 274 Mishap 593, excuse me. The Court of Appeals construed the statute as limited to true threats so as not to infringe on First Amendment protections. True threats, the court explained, encompass those statements where the speaker means to communicate a serious expression of the intent to commit an act of unlawful violence to a particular...
Stop. We'll stop right there. So, a true threat, as articulated by, I think it was Judge Calvin in this matter, says a true threat is a statement by the speaker that communicates a serious expression of the speaker's intent.
The intent to commit an act of unlawful violence.
All right, stop right there. What was the speaker's intent? I'm just analyzing this. This thing says kill the police, kill James Craig. What is the serious expression of his intent to commit an act of unlawful violence? We know the unlawful violence is kill all the police, kill James Craig. That's not even an issue. That's killing anybody is a violent, unlawful felony. So I'm okay with that part of it. But what I want to know is, what was the serious expression of his intent?
That is a serious expression of his intent. He's putting that publicly on the wall for everyone to see that may go by there. The person need not actually intend to carry out the threat, but have the general intent to communicate a true threat. We, as was testimony here in this court, this is a situation in which we have an individual that has been arrested, is taken to the Detroit Detention Center, and counsel asked some questions about his attitude with the arresting officer, but the court can see from the videos that we have a situation in which this individual is slamming the door open upon his exit of the Detroit Detention Center. He slams the door and he's going out at 8:17. At 8:34, this vehicle arrives back at the house. Looks like the exact same vehicle that's involved in the felonious assault just 2 days earlier. That vehicle pulls in the driveway consistent with this defendant's house, and 4 minutes after that, this person goes right to that wall. This is not just speech or distaste. This is someone that is furious, that is trying to threaten acts of terrorism, threaten all police, threaten the chief of police with these words that are printed on the wall by him. This is not just expression. This is threat. He doesn't need to intend to carry out the threat, but must have the general intent to communicate the threat. The act threatened must be a violent felony that he knows or has reason to know is dangerous to human life. Threatening to kill someone, killing someone is dangerous to human life. The defendant must have a general intent to communicate a true threat and must have intended to intimidate or coerce a civilian population or a unit of government through intimidation and coercion. This is his intent, not the results to the police department. The police department is not going to stop policing in that area because of being concerned. A person who is just spouting off likely does not intend to communicate a serious expression of the intent to commit an act of violence, nor would he intend to intimidate or coerce a civilian population. That's not this defendant. This defendant is trying to coerce that population. He's trying to intimidate the people at hand. He is going there immediately after being released from the Detroit Detention Center and communicating that threat, spray painting that threat against the wall. It doesn't matter that he doesn't have an arsenal of weapons. It doesn't matter that he can't do any of those things himself. It's the threat. It's the terroristic threat causing people to be scared, to be terrorized, to be frightened of this individual and individuals like him doing similar circumstances. That's what we're doing here. And as counsel stated, in 755.43M, subsection 2, it is not a defense to a prosecution under this section that the defendant did not have the intent or capability of committing the act of terrorism. It's that he did it. We're not talking about just words. We're not talking about speech in this manner. We're talking about the kind of words he chooses. He doesn't choose things about I dislike or I distrust or I have disdain or even expletives regarding the police. He's making those commands, those orders, those threats. Kill. Kill all police. Kill James Craig. That demonstrates that this is more than just speech, that it is a terrorist threat with respect to this defendant, and it presents a question of fact for a trier of fact for the court.
Well, I think it's a question of law. I don't think it's I mean, I sat here and I listened to all this, and I did some research before listening to this, and I have some serious questions about the extent that the statute violates First Amendment to free speech. So kill the police, kill James Craig is a command to do something to the police and to James Craig. But to who was that command made? I did some research. I looked up, this is First Amendment rights not absolute. So you can't holler fire in a crowded theater, especially if there is no fire. So in looking at this research I ran across, it says First Amendment protections are not absolute. So you can't yell fire in a crowded theater. Governmental regulations of certain categories of speech is permissible without violating an individual's right to free expression, such as statements deemed to compromise, quote, true threat. So first of all, this had to be a true threat. And then it goes on to say, which encompasses those statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or group of individuals. Well, let's take that sentence apart. So, the unlawful violence directed at the particular individual would be Police Chief James Craig, and the group of individuals would be the police themselves. So, it says a true threat is a statement where the speaker means to communicate a serious expression of an intent. So when I was reading this, I'm like, well, whose intent? Of an intent to commit an act of unlawful violence to a group of particular people. So did Mr. Lewis communicate a serious expression of an intent, of his intent, to commit an act of unlawful violence against the police or Chief Craig is the question. And I would agree, this is going to be a question for the trier of fact. They're going to have to sit through this and figure out, is spray painting ugly commands, actually 2 ugly commands on the side of a building constitute a true threat when there are no other actions in furtherance of that true threat. So can we impute or compute to Mr. Lewis what someone else might do based on what he sprayed on that building? Someone might, a lot of people will not.
Ma'am?
Yes, you may.
Your Honor, I think we cannot ignore the fact that the statute requires that he specifically have an intent. And the prosecutor is double talking. I mean, she started out at the beginning and said he wants people to be afraid of him. He wants the police to be afraid of him. He wants them to think he's going to be a danger to everybody in the community. If he had done it, he would have signed his name. If he wanted that result. But again, I submit there is no evidence on this record that this is any more than ugly words. It is not a credible threat, if a threat at all. But certainly there is no evidence of his intent to affect the conduct of government as a result of that.
Mr. Marcus, you want to respond?
And, Your Honor, I think we would take counsel's argument to be that that he would have signed this if he intended for him to be the one communicating that threat. There are many circumstances in which someone is both bold and cowardly, and I would submit to the court that this is that kind of action. He's so bold as to write, "Kill all police, kill James Craig" on the wall, but he demonstrates that he's not as bold as he thinks he is sometimes, and he's bold and cowardly. And I would submit to the court that that is the circumstance for basically every terrorist situation. You have someone that's bold and cowardly for the actions that they take. And I would submit to the court this is a question of fact for a trial.
Well, I don't know if you not wanting to be apprehended as cowardly. People always throw a rock and hide their hands. I wouldn't say it was cowardly. What I would say is they don't want to be caught.
I'm not talking about not wanting to be caught as the cowardly part. I'm talking about wanting to threaten people in this manner and do things in this manner because of the actions that they took with respect to other things. He's arrested for felonious assault. He's pointing a weapon at the repo man, and he's arrested as a result. And his reaction is to lash out and make these threats against the police and do these kinds of things.
Well, see, you keep saying threats as the definition of a word. So when you say he lashes out and spray paints us on the wall,
it's the people's
is it threatening to the police?
Yes.
Absolutely. But that isn't how the statute reads. Ms. Peterson, what did you want to say?
I just wanted to say that true threats are best defined in the Quigley and Ostenkowski cases. When we consider the fact that there were actual acts that they took to demonstrate, to manifest their true threat. Even though they may not have been able to facilitate the fullness thereof, there were acts. This is words. And there can now be implied the specific intent of an action to affect or influence the conduct of government through intimidation.
Or others. You keep saying government.
I don't believe kill the police, kill James Craig threatens the civilian population.
No, that's not the point I'm making. The point I'm making is anybody who drives past that wall
Correct.
Is affected. They see the command, kill the police, kill James Craig.
Correct, but they are not intimidated or coerced, which is what the statute says.
Well, it has an effect. You were talking about the effect on government, but I'm saying...
Correct.
Okay.
Because I don't believe there's an intimidation factor or a coercion of the civilian population by those words. In fact, there may be a lot of people that agree with it. But the effect and influence on the conduct of government or a governmental entity through intimidation and coercion, it just does not exist here.
Okay. Well, when I was reading it, I did, as I had said, I did some research using Westlaw. What struck me was that the person had to do an act in furtherance of something. So what we're alleging is was pretty clear is that based on the testimony I heard from what's the young lady's name? Miss White-Horn. She recognized the handwriting on the wall as belonging to Mr. Lewis. So Mr. Lewis did something, and the something was to write some words on the wall. That was the first thing he did. People write words on the wall all the time. He wrote some ugly words, some hateful words on the wall. So does the statute cover hateful language? Or is it just broad and says if you do this, this, and this, then you're guilty? So I didn't see anything about hateful language in this, in my research. There's maybe another statute, I don't know. If not, there probably ought to be one that's more specific. But in any event, 750.543 AL provides a person is guilty of making a terrorist threat. I'm not going to deal with the false report because he didn't call anybody or make a report. If the person does either of the following: threatens to commit an act of terrorism. So first they've got to do something. They have to threaten to commit an act of terrorism. Is the writing on the wall sufficient? Is that enough? Is that a threat to commit an act of terrorism? When you say kill X, Y, Z, is that sufficient? Secondly, it says, and the person has to communicate the threat to any other person. So this threat is communicated to, or this command is communicated to everyone. But is it a threat? I know the police feel threatened by that message on the wall. There's somewhere, let me see, hold on. Then we go on to subsection 2. It's not a defense that the defendant didn't have the intent or capability of committing the act of terrorism. Once again, you're using the word to describe the word. My second grade teacher would be appalled. And then they go down further to define what is an act of terrorism. It says it is defined as a willful and deliberate act, that is the doing of something, could be spray painting on a wall, that is all of the following: spray painting on the wall, an act that would be a violent felony under the laws of this state, whether or not committed in the state. It's the spray painting the ugly message on the wall, an act that would be a violent felony under the laws of the state. No.
It's not that act that we're talking about.
You're talking about the effect that message may have on someone else.
The act that we're speaking of is the kill all police, kill James Craig.
That's not an act. That's a phrase on a wall.
That in this circumstance,
it's telling people to do something. It's telling them to kill the police, kill James Craig, but it's not. And the act itself is the doing of something. An act is the doing of something. Spray painting on the wall, kill the police, kill James Craig, fuck the police, all those commands. Right. So he spray painted on the wall a command for everybody in the world who drove past that intersection to see.
The act that we're speaking of is the statements of kill all police, kill James Craig. Those
What's the difference between that act and his right to spray paint on the wall protected by free speech?
We're not talking about the act being spray painting on the wall. That's not a violent felony under the laws of the state. What we're talking about being the act under this circumstance and under the definition and under the act of terrorism would be the act that is kill all police, kill James Craig, inciting someone.
But he didn't do that. He commanded people to kill the police, kill James Craig, but he himself did not go out and kill anybody or kill the police. And he wrote it on the wall.
And as to subsection 2 of 750.543M, it is not a defense to the prosecution under this section that the defendant did not have the intent or capability of committing the act of terrorism. So it's not a defense that he didn't actually kill anyone or try to kill anyone or have the capability of killing anyone. It's that he used this threat, this action. He writes on the wall, kill all police, kill James Craig. Those would be the violent felonies. Murder or inciting murder or trying to get someone, being an accessory to murder, those kinds of things. That's the violent felony we're talking about, not spray paint.
Well, maybe you're just intentionally not understanding what I'm saying. I understand an act is something that you do. You speak, you write, you sit, you sleep, you laugh, you cry, you punch somebody in the nose, you do something, and what Mr. Lewis did right now is right on the wall. If he had wrote Merry Christmas, Happy New Year, we wouldn't be here, right? Because that's just a misdemeanor spray painting on the side of somebody's building without permission. Of course, if you're a different religion, that might be an act of terrorism too. Who knows? I mean, if you're Muslim and you don't believe that, would that be construed as an act of terrorism? Merry Christmas, Happy New Year?
No, the act is the violent felony that he's inciting. If he said, blow up this building,
okay.
If he said, kill all police, that's what's important here, and that's the act we're talking about. Not someone tagging their name, like Stuart was here, or if he had some sort of other thing on the wall.
Mm-hmm.
What we're talking about is what he's inciting someone to do, whether it be himself, someone else, or what he's trying to communicate to the unit of government, the executive unit of government that includes the police department,
mm-hmm.
to cause them to have concern about their safety, to cause them to, react in some kind of way. They are serious about their reaction, but as I stated before, police don't run from danger when it's happening. That's not what they're trained to do. That's not what they're for. So he didn't get the results that he wanted, but he had that intent. And we're not talking about the act of him physically spraying the wall. We're talking about the act of what he's telling someone to do. Kill people. Kill all police. Kill James Craig.
And again, Your Honor, I'm going to go back to Untitled and quickly. The defendants in those cases, one has gone into a bank or some public facility and said, I'm holding her hostage and I've got a bomb. And Subsection 2 that says it's not a defense, that he's not got the capability, he didn't really have a bomb. He had a phone or something else.
Well, people thought he had a bomb.
They thought he had a bomb.
That's good enough.
And he got the reaction from the governmental entity because they all swarmed there. I think, I'm going to the school and I'm going to shoot these people and blow up this and do that. And he got the results. Though he may not have been ready, able, and willing to do it at that time, but those cases show an actual intent. And I also agree with this court. The willful, deliberate act in this case is painting on a wall. And that is not a violent felony under the state of Michigan law.
So then, if I understand this, then Mark, the painting on the wall is not the violent act. What you're saying is what he painted on the wall is the violent.
Yes, he's communicating that to the public. He's saying, this is what I want done. Whether me or someone else, this is what I want done.
Well, you know, that's a radical departure from those other two cases where the defendant communicated, I'm going to do such and such a thing. I'm not waiting for somebody to go past this building and decide that, yeah, I think I will go kill the police.
And he may have been intending that he was going to do it himself. I don't know that he had the capabilities at the time.
Doesn't
but that's
matter.
Not something that's required by the statute
That's
either.
true. That's true.
He's not just saying he doesn't like someone, or he's not.
Well, he absolutely is saying, I don't like the police when he writes the command, kill the police. I mean, that's a pretty clear expression of your disdain for a group of people.
And I would
kill
submit
them.
that it's more than just disdain. It's a threat. Kill all police, kill James Craig. He's talking about killing people. He's talking about a violent felony of murder.
Well, that isn't even in dispute, and that's for sure. That, as I indicated earlier, the message is hateful. Kill the police, kill James Craig. Is it protected by the First Amendment is the issue up here before me. Does it fit under the statute that he's charged with? And I'm having trouble with this act thing. The act that he did was to walk out, to get out of jail, angrily. I mean, he walked out of jail throwing roses and sucking lollipops. So he slams the jail door. That doesn't mean anything. 20 minutes later, he's seen walking across the street from his house to where the painting is done. So the act, he has to do something. I wrote an act in furtherance of the threat. So if you're saying the threat is writing "kill the police" on the wall, what act is he doing in furtherance of that? That's what I'm struggling with.
And I would submit to the court, there's nothing in the statute that requires there to be more than one act.
What act are you, but the act that you're talking about, I'm talking about the spray painting on the wall, that's a misdemeanor, that's not a violent felony. So he has to do some sort of violent thing in furtherance of it.
What he's commanding, what he's asking for would be a violent felony under the laws of the state.
That's true. Commit murder, kill the police, kill James Craig.
And he's putting that threat on the wall. He's making it a true threat. He's placing it on the wall for the public to see.
Wait, stop. You just used the phrase from Austin Housing case. What is, and I think I wrote down, what's the true threat? What's the true threat here?
Kill all police, kill James Craig. I would submit to the court as a true threat. He's putting it on the wall so that anyone can see it. It's open to everyone. He's not just somebody sitting at home angry about what happened and muttering to his girlfriend or himself or someone else, or saying just to someone in some small communication that he's upset about what happened or that he doesn't like something. He knows or has reason to know it's dangerous to human life. He's intending to intimidate or coerce a civilian population or influence or affect the conduct of government or a unit of government through that intimidation and coercion. He puts it on the wall. It's a public place where he puts it so that it can be communicated to anyone. He's not just quietly dealing with this himself or just in a small circle of people. He's communicating this to another person so that it can be communicated to the people that it's directed at. Kill all police, kill James Craig.
Well, I disagree. And I'm looking at the statute and what it says, that a person is guilty of making a terrorist threat if he does the following. A, threatens to commit an act of terrorism. So he has to make a threat. He has to communicate to somebody, I'm going to do something. I'm going to blow up, tear down, shoot, kill somebody or something somewhere. So first he has to threaten to commit an act of terrorism, which is a terrible explanation. And then there's the word and, communicate the threat to any other person. So I don't have a problem with the and part of it, because he put this message on the side of a wall of a building at State Fair in Exeter. So it's been communicated to others. I'm having trouble with the threaten to commit. It says the person is guilty of making a terrorist threat if the person does either of the following. Threatens to commit an act of terrorism and communicates that to somebody. Knowing it, well, that's a false report. I'm not going to talk about that. And then they go down further and define what an act of terrorism is, because it says threatens to commit an act of terrorism. So the person has to make a willful and deliberate act that is all of the following. An act that would be a violent felony under the laws of the state. An act that the person knows or has reason to know is dangerous to human life. An act that is intended to intimidate or coerce a civilian population or influence or affect the conduct of government or a unit of government through intimidation or coercion. So she says, yes, we're aware of the threat, but we're going to keep on doing our job. So that it doesn't fit under that explanation. The phrase act of terrorism is a willful and deliberate act that is all of the following. An act that is the doing of something that would be a violent felony under the laws of the state. Now, there isn't a dispute that the message is violent and hateful and against the laws of the state, kill the police. But it doesn't say that the message has to be hateful. It says an act that would be a violent felony. Only act I heard that Mr. Lewis did was to spray some hateful language on that wall. And I'm going to dismiss the terrorism charge. I don't think the people have made their case in this matter.
Thank you.
He is bound over, however, on the possession with intent to deliver a controlled substance to wit marijuana and the amended count 3 on this file 16-61509, and he is bound over on the felonious assault and the felony firearm on file number 16-61577.
And Your Honor, I do have to address one issue. The complaining, I'm not sorry, not the complaining witness. One of the witnesses was not actually called for the preliminary exam, but was a witness that statement is in discovery. He is the owner or worker at a paint store that the defendant frequented prior to his arrest. Did contact, Joel Desmond, did indicate to the officer in charge that the girlfriend of the defendant,
Ms. Gray?
Yes, has called him a number of times, arrived at the paint store a number of times, making demands of him that she wants to see documentation and things that he has. Mr. Desmond wants no contact with the defendant or anyone acting on his behalf. He's concerned about the repeated contact that was made towards him by the defendant's girlfriend, Ms. Graves. This all happened yesterday and possibly the day before, right before the court hearing. And so I would ask the court to communicate to the defendant again, and anyone that's here on his behalf, that they are to have no contact with the witnesses in this case, and that if that occurs, the defendant's bond can be affected, that those individuals can be subject themselves to charges potentially for witness intimidation or other things if they rise to the level necessary for that.
Okay. Mr. Lewis, did you hear that? Tell your girlfriend, whenever you talk to her, don't bother that man anymore. We'll lock her up, and if you're not locked up, we'll lock you back up. I mean, if you aren't locked up, we'll lock you up. Any questions about that?
Well, you have my word. I will contact her and let her know.
All right. Now that we've got that out the way, Mr. Lewis's bond on the terrorism charge was set at what? It was like 25,000, 10%. Wow. And on the FA, $75,000 cash security. All right, Ms. Peterson, I'm sure you wish to address his bond.
Absolutely, Your Honor. And as much as the most severe charge has been dismissed, Mr. Lewis does not have any convictions since 2002. He has no patriot history. He has been steadily employed for the last 20 years. He is a homeowner and a lifelong resident of the city of Detroit. He has every intention of returning the answer to the charges that remain. I submit he is not a violent threat at large to the community.
I don't know about that. I don't know. I don't think so.
With Mr. Perry. However, I believe that a tether can address that. He has no reason to have any contact with Mr. Perry. The car is open. And so I'm going to ask the court to consider reducing his bond appropriately. In this court's discretion, I know you'll do what's fair and just.
Always.
And
the only way I know.
I would ask you to make that consideration in light of the circumstances of the changes of charges.
Ms. Van Martin?
Your Honor, I would ask the court to keep the bond high. This defendant, I think, has demonstrated that he has issues with authority, with the police, with following the law. We have a situation in which he's on video assaulting with a weapon an individual who's there to repossess his vehicle, an individual that doesn't have the ability to even take out his paperwork. He's in a vehicle marked with his company's markings. He's wearing a shirt that says repo agent across the back, and the defendant's response to that is to come out and say, I'm going to blow your shit up, I'm going to blow your head off, and point a weapon at him until that individual leaves the vehicle where it is. A vehicle that he then later admits to the officers that he's been having trouble paying the bills and all of those kinds of things. And he had a weapon at the time, a pneumatic gun. In addition, we have a situation in which he's released from the jail, and he immediately goes and does this. Spray paints this threat on the wall, and indicates that kill all police, kill James Craig. He has marijuana in his home, similar with packaged for sale. He's destroying the property of an individual across the street from him. You've heard testimony from Ms. Asia Whitehorn today regarding incidents with her. I think it's clear to the court that she's very scared of him, and that he's demonstrated that he is a reason or has intent to scare and terrorize a number of people. We have a situation in which just a moment ago I had to address a contact that was had with the girlfriend of the defendant and this individual who's a witness. And we were here 2 weeks ago, and the attorneys were withdrawing because the defendant said they weren't speaking to his girlfriend enough. So I would submit to the court that...
I'm so sorry, I am completely out of sync.
Okay. So I would submit to the court that based on all of that and what we know from the previous hearings with the defendant, he's well in communication with his girlfriend, Ms. Graves, and I would submit to the court that he's controlling those activities that she's doing, and he's telling her to do those things, to contact those people. Given the fact that we have all of that information from previous situations that the defendant is communicating with the girlfriend, wants his lawyers to communicate with the girlfriend. So we have someone who's making contact with the witnesses from the jail through a third party. I don't think that his bond should be changed at all, if at all, very little. I would also submit to the court that the information the officer in charge has is that the defendant was evicted and would not be staying back at that location, and we don't know where he would be staying. So if there is any adjustment of bond, I would ask that, of course, the tether be included so that he can be kept monitored and contact about where he is and where he's going, that there be no contact with any witness in this case, no contact with 200 West State Fair, and no contact with police unless it's an absolute emergency with regard to this defendant.
And I think that all those conditions are warranted. I am going to reduce Mr. Lewis's bond on each case to $25,000, 10% plus GPS tether, no contact with any witnesses, Mr. Lewis. If your girlfriend contacts the witnesses, if your mom, your sister, your brother, or somebody contacts the witness and the witness tells the police they've been contacted, your bond will be revoked. Any questions about that, sir? All right. All right. Here we are. You going to give them back to your exhibits? Here. Just wait for the remand. Huh?